Powerful. All right, let's call our meeting to order. Friday afternoon.
Ellen Tchaikovsky, Office of Legislative Counsel. I am here on Act 250, and on the screen is a graphic you have seen previously. It is the categories of topics not directly addressed by the joint proposal that are currently in your draft 9.2. And so we're going to discuss them for whether they're going to be kept in the next draft. So the first two.
He's got copies of them. It's probably one of these.
Oh, when we ended up.
So the first two are about the organization of the criteria, and I think we already have addressed them based on our conversation. So your bill in draft 9.2 reorganizes criteria 1, 2, and 3 so that air and water are separate criteria. Currently in Act 250, criterion 1 addresses undue water and air pollution, and then 2 and 3 also address water. So we separate 1 into being air only, and then 2, we don't change the language of 2 and 3. We just merge them. So based on yesterday's, and then also in your draft 9.2 adds sub-criteria 1A, which is air contaminants, and 1B, greenhouse gas emissions. So based on yesterday's conversation, I believe that we decided to, yes, leave the reorganization of water and air, but take out sub criteria 1A and 1B.
I agree.
Okay. So,
just quickly looking at what the language is, and I don't have it in front of me. I know we talked about taking out greenhouse gas emissions, the 1B, because we dealt with it, but was there already existing language on air contaminants? I just couldn't remember.
sure, so if you want to look at the language, it's in draft 9.2. It's on page 33.
Okay, good. Nope. So we just separated it out, leaving the same language. So it still refers to the applicability of Clean Air Act. Okay.
Yes. Yep.
So yeah, that whole paragraph 1 stays.
Yep.
Yep. Just checking.
All right.
Wow, we're moving along.
So, but A and B are gone.
A and B are gone. Which I think that makes it pretty clean too. Those two things are addressed.
30. Great. Okay. Next up.
Okay, next. So, the definition of commercial purpose. Your bill, this is going to be on page 12 of 9.2, but your bill adds a definition for commercial purpose. Currently, there is a definition of commercial purpose in the Act 250 rules. Page and this language was added to clarify a discrepancy that occurred recently. I'm on page 12. The definition of commercial purpose is on line 14. So we're in the definition section of Act 250. So you may recall that very often when we talk about jurisdictional thresholds, we talk about commercial or industrial purpose. So since 1984, there has been Vermont Supreme Court precedent on what a commercial purpose is. And recently, in 2018, there was another court decision that overturned that precedent. So previously, under the precedent, nonprofits, including churches, still could be found to have a commercial purpose. But the new court ruling would basically exclude nonprofits and other businesses or entities that accepted donations. So that is that's a change that the Commission on Act 250 was concerned about. Oh, so to take a step back for a second, the things that are in draft 9.2, to remind you, are all things that came out of the recommendations on the Commission of Act 250, the next 50 years. So the reorganization, we did have testimony in here, but we also had testimony before the Commission, and it's discussed in the report. Same with this definition of commercial purpose. There is a section on it in the report from the Commission that talks a lot about the confusion around the change in precedent. So by adding this definition into the statute, so the attempt was to go back to the original the prior understanding that nonprofits could be considered a commercial entity. So the language, commercial purpose, means the provision of facilities, goods, or services by a person other than for a municipal or state purpose to others in exchange for payment of a purchase price, fee, contribution, donation, or other object or service having value, regardless of whether the payment is essential to sustain the provision of the facilities, goods, or services. And so that last clause, starting with regardless, is what the court is language that came out of the court case. So.
Yeah. Do you have to be registered as a nonprofit in order? If you were not registered as a nonprofit and you were providing let's say a snowmobile or a ski trail rather, and groomed it and everything, and people had a can there and people were throwing donations in, that now be called commercial?
So this is not, we're not using the word nonprofit in any way. This is talking about regardless, yes. So it's regardless of whether the payment is essential to sustain the facilities.
That would be the right line, in other words.
Yep. So we're talking about usually the construction of improvements for something. Construction of improvements for a commercial purpose, and this is how you would decide.
Other questions on this one?
And how would it apply?
So previously, for 30 years, nonprofit entities have a commercial purpose under Act 250 and have to get a permit if they met the other threshold. The court case found that if you were accepting donations, you didn't necessarily have to get a permit even though you were constructing improvements.
It's to clarify that you do.
Yes.
Okay, thank you.
So the next,
So do we need a statement to say, yes, let's keep that in, even though there's, I suggest we keep it in.
Okay, I agree.
all right, the next,
I'm sorry. Keep in the regardless, Jim.
Well,
Definition of
for the purpose of the next iteration, we keep it in, keep that So
Keep this
40
definition.
Yeah,
Okay.
definition of commercial purpose.
So the next topic is the development cabinet. This is on page 78. So the development cabinet was an entity
Oh no.
that has been in statute for a long time. It included the secretaries of administration, agriculture, food and markets, commerce and community development, education, natural resources and transportation, and they would meet and work to coordinate on
Larger developments.
larger, yes. And they had not been meeting regularly or at all, and so language was added attempting to get them to meet regularly. Last session, this section of statute was repealed, and the development cabinet is no longer in statute. So if you would like to see this, we would need to re-add it in statute even though it was just repealed.
And it was, let's see, it was created. It's been pointed out to me that a governor could do this anyway, if they wanted to do it. And so, I'm not sure if there's a compelling reason for us to have it in statute.
Did the joint proposal approach that?
No,
No,
this is the list of things they didn't.
they left out. Mm-hmm.
That we're going through.
So, yeah, I got one, thank you.
Other thoughts? Any reasons that we wanna have it reinstated? They weren't meeting, we can't tell them to meet their executive appointments. It's a good idea. Apparently was at one time helpful. Okay, we'll take that out.
Alright. The next item is an increase in the per diem rate, which is on page 24. We touched on this a bit yesterday. Oh, it's on page 25. Yeah, it's on page 25. We touched on this yesterday. So members of the district commission shall receive per diem pay of $100 and all necessary and actual expenses.
But the original language doesn't have a number.
Right, it cross-references the general state per diem, which is $50.
It's still $50, the general state per diem?
Yeah.
Okay, so depending on what we end up doing with the board structure, there may or may not be money in our bill, and I don't think that changing this to $100 warrants the review by approach. So we could, I think that should change. We should change it, but we can change it through the budget. So that's, I just think we should change it, and I think we should, as we talk about the board structure, we should talk about this further, I think, but it should come up in that conversation.
Mhm.
And so I'm saying for now, let's just hold it for now. That's,
Okay.
I mean, take it out.
no, just the
Keep it
little
at,
flag.
keep
whole
the original
little
language.
flag on it.
I think last spring, last time, we had changed that from 50 to 100, as it sits now.
Well, we added the 100.
Yeah.
Yeah,
Yeah.
we did, and I don't disagree with that, but I think we may or may not need to have it in there to get to the same end. Okay, Jim?
I can agree with that statement also, except I think since, oh, wait a minute. I was gonna say, since the $100 is in the underlying bill, they'll go look at it anyway. But I think Lee, you just said we stuck that in there last
Yeah,
year.
yeah.
So it wasn't in the underlying bill.
It's a committee bill.
There's no underlying bill.
Yeah. Good, one complication dealt with.
Okay.
I hold it.
Next is slate quarries, which starts on page 29. Well, at the actually on the bottom of page 28, we add this language that on or before July 2021, July 1, 2020, owners of pre-existing pits and quarries shall submit extraction data to the board in order to establish a baseline against which substantial changes may be determined. So you may recall that pre-existing pits and quarries, and in general, any pre-existing development that doesn't have an Act 250 permit because they've been in existence since before Act 250 was created. Let me take a step back. Things that were in existence before Act 250 were grandfathered in and don't have to get an Act 250 permit until a substantial change occurs, and that is when they would have to apply to get a permit. So currently, there are a number of pits and quarries that were pre-existing to Act 250, and so they don't have permits. And there has been some litigation. The testimony you received was that there's been litigation because it is difficult to determine when a pit or a quarry has a substantial change because there is often no data regarding what their prior extraction rates were. So it's difficult to determine at what point they need to get an Act 250 permit.
And other quarries, oh, this would be everybody.
Yes.
Okay, right, okay. Moving on to slate, unless someone has a question about this.
Pre-existing would be 1970.
Yes.
But substantial change has been determined for quarries. And do you know how that's been happening?
Sometimes what happens is someone makes requests a jurisdictional opinion, asking if a change, it could be a neighbor or someone asks if a change that they've seen qualifies as a substantial change. I think, I don't have much to support this, but I think what often happens is someone outside of the actual owner of the quarry says something is different, they have added new machinery or they've expanded and I'm feeling impacts, do they now need a permit? And they ask, and there are times when litigation is needed to determine because evidence is needed to be taken on comparing if it's substantial. So there is precedent that establishes what is substantial change, but it can be difficult in these operations when there wasn't baselines set.
So will this bring all quarries, all slate quarries under Act 250 now?
No.
This is for all of the extraction businesses to establish their baseline.
So that in the future, when they do make changes, there is a sort of threshold determined at which point they will need to get an Act 250 permit. It's sort of trying to provide clarity at when a pit or quarry expands, at what point do they need to get a permit?
Is that over a certain period of years?
No.
So, they have many quarries that aren't utilized and they want to go get a different color and it hasn't been used for 10 years. Is that a substantial change? Now do they have to go through 250 to open up that unused but mapped quarry?
No. So that's slightly different because the slate quarries have some extra protections, and whether or not you keep that with slate quarries, they're considered held in reserve. And so depending on the change you make in regards to slate quarries, that could be different, but other types of quarries, other rocks, don't have those protections already. And so potentially, if someone who is not mining slate, who is mining something else, begins a new quarry, that's not a pre-existing quarry. That is a new quarry, and they will potentially need to go through Act 250 if they hit the jurisdictional threshold. And there are a number of the earth extraction industries have Act 250 permits beyond slate.
So we spent a fair amount of time with slate so far, and I'm trying to remember if we took testimony from other quarries that would be affected by this last year. We haven't taken any this year. And when something like this goes into effect, how is there a process by which the people affected are notified and given some way of fulfilling this, like an outline for how to do this, or a form or something?
So it does have a deadline on there, and
We're not gonna make that,
well,
but yeah.
I mean,
No, I know,
maybe.
it gives a date, but it doesn't, how, it's not a retroactive, I mean, it's like we're asked, how does this get implemented? Who implements this? The board?
So the board has enforcement authority. I think it will fall to them in a lot of ways on how they're going to try to implement this law.
What's the board here again? Is it NRB or the enhanced board?
It's the NRB.
NRB.
We haven't enhanced anything.
Well, hopefully not.
Yes, nothing has been enhanced.
Representative McCullough.
Two things. One, talks about on line 6, in answer to what board? It's Board of Health
No.
in existing language. So that's a bit confusing. But be that as it may, we did not take any testimony and from anybody but 5,000 Slaters. And I don't think we can put this in without
either.
testimony.
Yeah, I don't think we can. So either we need to take testimony or take it out. It did come from the commission process, but
Good idea,
yeah.
one would think, but,
But it may affect, anyway, yeah. I don't know that we did. I think we could search under quarries from last year, maybe that would help, but.
perhaps the Senate will take some testimony on it.
So this is just subsection B.
Well, yeah, and I guess permits required exemptions, subchapter 4, this is a,
Yep, so we're in the exemption section of Act 250.
okay, thank you.
Yep. We're in 6081.
Page 28.
It does make you wonder what subsection A is. That's our assignment this weekend, everyone's gonna go read the whole
Do you want,
Act
so
250 section.
subsection 1 of 6081 requires that anyone who is constructing improvements needs to get a permit, either for development or subdivision needs to get a permit. So that is the affirmative statement that a permit is needed. And then sub B starts with a very long list of exemptions to that general rule.
Yeah. Subject.
Yeah, let's check the board. I read the Board of Health right now.
Alright, So I think we need to take it out. And then I guess the next pages is the slate quarry.
Yes. So, your current draft, 9.2, only contains a change in relation to slate quarries in that it deletes the held in reserve provision. So, the original draft repealed a lot of the existing protection for slate quarries, but this is where we landed at one point last year was, so currently, as Representative Morgan was discussing, multiple holes on a registered slate quarry site, if they're not being used, generally under law, are considered abandoned. But because of this sub J at the top of page 29, for slate quarries they're held in reserve and not abandoned, so they continue to have the exemption. So your bill currently repeals that so that slate quarry holes that lie unused
But
will
in
be
reserve, but in reserve.
Or reserve.
No, will be considered abandoned.
Even
And-
though they now say they're in reserve, they're still considered abandoned.
We've struck it.
Under this
If we
language.
strike J,
If we strike J,
we're talking about this right now.
they will be considered abandoned and not held in reserve.
But if we keep J, get rid of the strikeout, the status quo is in effect. They are still wheelbarrow-sized reserve quarries. Many of them, I think.
Well,
Yep.
I've seen them and I didn't see any that small.
Yeah.
Thoughts, committee?
Well, the testimony we got from Annette Smith and some of the slate owners seemed to be at odds. She thought it was no point in continuing the negotiations. And they thought they were still possible resolutions where both sides could agree, they and the neighbors. So I'm not so sure where things stand between the two parties that really kind of the reason we're even considering this exemption. We don't have any guidance, unfortunately, on how things are working out if left alone.
My opinion is not strike that. Necessary. I don't want it. Strike. I don't want that. Those lines don't shoot.
Okay, here,
Yeah.
you don't want, you don't want to strike it, but what was the last thing you said?
I don't want the lines drawn through that. I don't
Oh,
want it.
oh, I thought you said something else.
You would, yes.
Here, there's no.
We had asked for a committee of sorts to come together
We did.
over the course of the summer and the fall and try to come to a common ground about how to support the industry while at the same time minimize those impacts on neighbors. Did we, I understand that they didn't
The administration
necessarily,
did not pursue that,
and the NRB didn't.
but it's the NRB.
Okay. Because then we had, it's unfortunate, because we sent a letter without giving more formal direction, but had asked for some action on that, and I thought we had received testimony from the NRB that they could do that, they had the resources, or they could assign one of their districts.
We did, but they didn't do it. So,
I just wondered, did anyone take the opportunity last summer to actually visit the site, the area down there? I know some
We have
people were
before.
going to. It's not what it's pictured in our minds as a massive, nasty, toxic hole. It's not like that.
asked that from other parties that were at odds. We let them know if they didn't do something, we would. And I don't know if that disclaimer was at play in this particular situation or not.
Yeah.
It wasn't.
I don't think so.
They did commit, I recall that the people that had come in representing the industry had come in and committed to developing and maintaining maps for informational purposes that can be used publicly.
So we have 90% of the maps, Chair Snelling brought them in. Billy, could you help us understand how something gets added to the NR Atlas?
Sure. For the afternoon, Billy Coster, NR. We host a web portal mapping atlas that has all sorts of layers of georeferenced spatial data. Some of that our agency develops ourselves and we publish it on there. Much of it comes from other sources. And as long as it's of sufficient quality and relevant, we're happy to host it. And
Yeah.
and I think, you know, the data that you saw that Ryan Knox presented is a close to complete list of map of these quarries. And I think we can put that on the atlas at any point once people think it's sufficient. And my understanding was the only issue preventing that from happening was the NRB getting some resources to pay for the mapping work to be completed.
I believe that's in the budget now.
Okay, so I think once that work is done, that can easily go up on the atlas.
Or could it even go up and have a disclaimer of this is, like, the what's the word for the wetlands map that's advisory?
It's advisory. Yeah, I imagine that could probably.
Could be advisory with in fact, I was watching the parcel data get populated this summer, so
Right.
it kind of kept getting added to with the understanding that
It was
we're not
easier,
finished, but it's
yeah.
coming. That's a little that's a little easier because you know which towns are done at
Right.
what time.
So yeah, I think that the short answer is we can host that information, and it's probably better to wait till it's complete. But if there's a real urgency to get it up now, I can certainly confer with folks to see if that's advisable.
The one thing I struggle with is that, I mean, here's a small industry with, it appears you have well, I've heard anecdotally that there's one bad actor there. But we also, it's unclear, it would have been so helpful if they had gotten together, because it's unclear that they have available to them guidance, technical assistance to understand best practices, or to understand about setbacks or about impacts to neighbors and how to minimize those. I know that there was reticence about crushing because it could trigger some commercial activity or some different type of action that's would constitute will trigger jurisdiction. But I guess I'm struggling with how taking the direction of best practices seems like such a logical need here. I'm struggling with this one because of the, you know, what with one bad actor and unfortunately some externality, some impact to adjacent neighbors, and that has a huge economic impact on their property value, I presume. So I'm struggling with this one, but I'm also empathetic to a small business model and how to provide that technical assistance. I know the Agency of Natural Resources has a pollution prevention program of sorts, and
what
a
prevention?
pollution prevention program where they provide the technical instance, bringing parties together and negotiate best practices. And they've done that with the brewers, as I understand, with sugar makers, and
Did they do that with them?
I-
What motivated those businesses to participate in that process?
I'm not directly involved in that program. My understanding is that within the environmental assistance program, there is some folks who do kind of sector-specific outreach, and typically they initiate that when there's an emerging business or when they're starting to see a lot of potential violations from the same sector. So when breweries were starting to expand, folks they didn't necessarily understand how to navigate the environmental regulations. We were seeing some bad outcomes, so they mobilized to kind of work with that whole sector. I think as we're seeing sugaring get larger, some of the same issues are. But I think if an industry self-identified that they would want that sort of sector-specific outreach, we'd certainly provide that. You know, and certainly if you want to speak with the folks who run that program, we can get them in here for you.
Yeah.
Wait, do the towns now have regulatory authority over extracting industries?
Karen,
Over extracting
Yeah,
industries.
industries extract something
From the ground?
from the ground. Is that-
You mean like slate quarries?
Or
I don't know in general.
Yes.
Gravel quarries, sand
Yes.
quarry.
Whatever.
Sure.
Yes.
We do, to some extent, yeah. Yeah. We do.
This is Tom Kennedy from the Regional Planning Committee. They generally regulate traffic, noise, dust, hours of operation,
Setbacks.
setbacks, things like that.
I do know that in less than a mile from my home, there's an open quarry, crushes stone. And it is highly regulated by our town. There are roads they can't drive on when they exit the place. There are certain hours that they can't operate. And I do hear explosions rock the house once in a while, and I can hear the crushers going, but and I relate it to the open pits down there in the southwestern part of the state. And I just don't see that those highly regulated companies already need to have more regulation. They have a lot of regulation from the federal government that they have to abide by, and I'm sure the towns also work with them as far as many of the things like hours of operation, et cetera. So I just don't think that's.
I hear what you're saying, but I thought that quarries were not the same as the others, so they're not as regulated as the other extraction industries.
Here,
Town by town, it's
Here in-
different town by town.
here in Vermont, that's all we have is open quarries, whether it's crushed stone.
All right.
No, but I think it's true that these towns don't probably have the same, like, I live near a quarry too. It runs perfectly well with residences around it because of regulations that the town has.
To me, we asked nicely, and it didn't get done. And then Paul, I think you were saying, did we say what would happen if they didn't do it? And I don't think we did threaten anybody, but I wonder whether we should just ask nicely again, and then, suggest that we would hate to have to come up with what we think ought to happen. So why don't they just get together and collaborate and listen to each other, et cetera.
Representative
Have a study or something.
McCullough.
I don't, here I am standing up for the quarries at the moment. I don't think we can say, why didn't they?
We didn't mean the quarries, why didn't NRB
Okay,
get
that's-
this going together? I don't
well,
understand why. I
well,
mean, I could imagine.
That's a good clarification.
Okay, thank you.
Um,
I'm just
having
thinking
said-
about the whole thing. Sorry.
Yeah, well, having said that, I think the very fact that other quarries around the state are heavily regulated by, heavily is could be fighting words someplace, but we've used that word today, heavily regulated by other municipalities. They are regulated by Act 250. And in Slate Valley, we've got a arguably very different situation. The municipalities do not appear to be regulating them very much, if at all. And there's a lot of political reasons why that's the case. ANR does not appear to be, this is according to testimony, appear to be regulating them either, because they say it's Act 250's job. And the district commissions say, well, they've got this exemption. It's a unique situation that was made a unique situation by a very political process by legislature in 70?
1995.
95. So, oh well. We are under that same kind of unique political situation right now. It's my personal opinion is they need to be regulated just like every other extraction business is in the state of Vermont, either through Act 250 and municipal regulation. Having said that, we've got a political reality that we may need to be dealing with, and say we need to just look the other way, and maybe this will get addressed somewhere else. Maybe it'll get addressed in a different fashion in the Senate this year. Maybe it'll get addressed in 5 years by a different legislature. Who knows? But we've got a lot of effort in this bill, and this is a possible dagger we'd be falling on if we tried to keep it in. And so all of that means, you know, for this particular section, where is it, section J, where the strikeout is,
Yes, section J.
you know, I'm agreeing with Lee. We can't do that today or Tuesday. We gotta unstrike it. There are other parts in here I think we can keep, but that wouldn't be one of them.
I think, oh,
I just want to make, it just seems that we're trying here desperately to solve a problem where there really is no problem. I just think that's the-
yeah, well, those of us on this committee, when we spent the time digging into it, have a pretty clear sense that, you know, we did hear, we saw a lot of pictures and videos, and it's, there are real concerns down there, but,
I feel, yes.
but go ahead, Representative Doyle.
A number of years ago, when we were undertaking the clean water bill, it was before my time in this committee, when we passed Act 64, but we recognized that small sites weren't controlling their stormwater, weren't managing it, and we required a stormwater guide and the development of those best practices and working with partners. And I wonder if, to the extent to which we can at least direct a plan which would involve collaboration among the NRB and NR to work on with the quarries to develop best practices, or at least meet about that and report back to us. Because I think this is, I agree, it's probably at this stage, it probably makes sense not to remove it, but I think we deserve the in recognition of that, of the need for best practices. That might be a logical way forward, so we can provide the right technical assistance to this industry and improve property values and the other impacts that we've heard about.
I guess I have a question about whether it's an Act 250 thing, or, like, if you're gonna, I like the path you're on, but is it really just A&R enforcement or A&R environmental assistance program? I don't know the rule for Act 250 in this, if we've,
Yeah, I don't see it's an enforcement issue necessarily, because we're not talking about discharges.
I think some of the landowners think there's some enforcement issues. But the environmental assistance program, I mean, I don't know, if that would make sense. Use that.
Yeah, and we could let the secretary of the agency determine the players. But in that way, we can keep it moving and work with all parties. That would be my recommendation.
Karen, did you wanna add something?
Thank you, and my apologies for dropping too quickly into a conversation. But if you were to ask the municipalities that do the regulation of those places down in the slate quarries and so forth, I think you would hear from them that they've spent a tremendous amount of time trying to come up with an appropriate regulation that balances the needs of the slate quarries, historic slate quarries, with the needs of the population. And clearly those issues aren't resolved, but they have been worked on for quite some time, and I think you would hear from those towns that they do regulate them.
I know last year we discussed it, it was our hope that the town and municipalities would be involved with the stakeholders and the owners of the slate quarries to kind of work out something, and, but that somehow, for one reason or another, has not happened, so we're kind of in the dark as to where it's at. When, Annette Smith, in her testimony, told us they were at odds and they didn't see any point in going forward, but the slate guys came in and said, no, it's not true.
I think we also learned that they have an association now.
Yeah.
I can't remember
That's
if,
right.
did everyone hear
That's
this?
true.
in
Yeah,
committee?
yeah,
Okay.
yeah, this is great.
So, all right, I don't think we should let this hang us up
No.
for too long. We're looking at a draft again on Tuesday. So, I think Lee's essentially made a motion to strike the strike.
Yeah, strike.
I move we strike the strike.
And don't cross that picket line either.
And don't cross
So,
me.
let's try that on. Let's try putting the language back for the next draft. Think about it over the weekend.
Before we move on, that reminded me of something that I wanted to ask before I forget again. So last year, with every draft that I produced, you had me leave the changes in and highlight them in yellow. And do you want to still see that?
No.
For example, you struck all of section 6094 from your bill, but it is still in draft 9.2. It's highlighted in yellow to remind you that it doesn't exist, but to remind you that it was there.
That one I think you might need to leave, because we're gonna get to it, and we might strike the strike. We might
Oh,
put
goodness.
mitigation back in.
Strike the
Great. Well, see, that's why
That's why we're
they're
talking about it.
highlighted in yellow, because
Yeah.
they're to remind you that you
No,
made a
I don't know.
decision.
Did we
you might
decide- we decided-
killed something you might want to resurrect.
I'm seeing the topic and then realizing I think we're leaning towards the joint proposal on this, and I believe there's still a conversation about mitigation, but the joint proposal is less prescriptive than ours. Am I right about this section 6094? Is the one about it defining mitigation?
It's defining mitigation, yeah. So I was just using it as an example of something that you struck but had me leave in the physical pages so that you could see that you struck it.
Yeah, well, I think it was super helpful to see that we struck it in this instance, but, whether we're ready to move it now, we might be ready to remove it now, but.
Okay.
I was one of the people who was hung up on mitigation.
Well, can we,
after hearing that.
I'm,
Focus,
cause like,
yeah.
just for a second before we go back to mitigation, so I'm mostly just asking, am I gonna delete this whole page from your bill? The slate stuff?
Oh.
Am I taking it out?
Yeah.
Or do you want me to flag this has been,
That's a great, yes.
that's, and we
why
can come
you're
back to
asking.
mitigation, I'm asking about what the next draft should look like.
Right.
Yeah, cause if we remove all our changes, why do we need it in here? It's the real question.
Yeah.
Are we confident doing
Yeah.
that now?
Yeah.
Cause we're probably not gonna take either of these approaches on how we address slate, is what I'm hearing.
Yeah.
Okay, yes, we are confident, we're comfortable with you removing this. I don't think we're ready for a blanket removal of all of the,
Okay.
but
Okay.
it's a good thing, cause we would love to get this to be shorter. So, yeah.
Okay.
Jim, did you wanna say something?
Well, I was gonna say a couple things. I think because we've been working with essentially almost 3 different documents, and I would advocate that we don't set a new precedent with this, because it's very helpful to have the new stuff highlighted and all the old stuff still there, so we can see the changes. But this is so huge, and the time is so short. I would suggest for this entire 9.2 to become whatever its next number is, with the co-layering of the other documents, that we just put down what it is we said we wanted to put down, and not go through that whole struggle this weekend of doing all that other stuff. Secondly,
I'm not sure that's gonna alleviate that, but.
Well-
I'm not sure that was clear to me. Are you saying kind of a clean
yes,
slate? Okay, so 10.1 or 2, however you do your 1s and 2s, will be what we've asked you to put in.
it'll be
And
clean
not-
without the,
Yeah.
yeah. The other thing is, I don't think this whole section wants to be dropped. We did decide to drop on page 28, lines 17 through 20, I think, but
Yeah, the next thing we need to talk about is on the bottom of page of 30.
yeah.
Yeah, that.
So you add language on the bottom of page 30. The registrant must provide notice of the slate quarry's registration to adjacent landowners.
Yeah, and I think we can leave that in. The various town clerks can go, oh yeah, thanks, but it should be a requirement. And it's there, and if followed accurately, it gives prospective new landowners data at the town clerks that would tell them there's something going on here if they didn't happen to notice. I think this can stay in and is not onerous against the industry.
Right, I think you can mix them. And then I think same on 31.
Yep. On 31, line 7, registered slate quarry shall be added to the A&R resources.
Yep.
I just named natural resources office.
Yep.
Okay.
Is there anywhere in here a line about having realtors have to disclose this on here?
No.
Did we talk about that? We maybe didn't take testimony.
What was the question?
There is nothing currently in your bill directing realtors to do anything in relation to slate quarries.
And I think that's the crux of the problem
Well,
right here.
Sure, it's part of it.
Going forward, it would certainly answer a lot
Misinformation.
of questions.
And I would be very angry also if I bought a home and I was not given information by people who were representing me. I guess they weren't representing me, but they should have divulged. And that's where I think this whole problem arose last year. We would never even be considering slate quarries had real estate brokers giving somebody bad information.
No information.
Well, maybe. I think there's some
Some other issues too,
There's
but
other
that's a big
issues.
issue. It's a big issue.
Yes, it is.
So
That's a
we
concern.
can
This could be a helpful solution. I again wonder about like notification of the realtors and how does that happen?
But shouldn't that be
Put it on
taken
that
up by some
form.
other committee who could, deals with real estate,
Yeah.
commerce, or I don't know.
I don't know who would actually, but no, But you're right, it should be, a realtor should let a buyer, if
I mean,
buyer is being represented by a realtor, they should,
A buyer can.
But
They're
pretty
not- they're always
important thing
represented
to-
by the sellers who do it.
well, not
But-
always,
Team,
but.
we gotta,
No.
let's make a decision.
But it would be nice if it were on that disclosure form that the realtors have to fill out.
But the way, isn't it?
Liability.
There's no.
We can't do that.
We
No,
can't do
we
that.
can-
No, without,
What
3 weeks of
disclosure is-
testimony from
Yeah.
every realtor in the state of
Okay.
Vermont.
Yeah, I think it's a good idea, but not now.
But not for
There's-
this bill.
and
And not
there's
for
no-
this.
All right, well then we'll just take it up after crossover or something.
And there's no
Okay.
disclosure.
Alright.
Moving on.
All right. Release from jurisdiction. Page 50.
Fifty or
50. So currently, Act 250 permits exist in perpetuity with 3 exceptions. 3 types of permits are issued for specified periods of time, but all other permits exist in perpetuity. So even if the land is sold, the permit remains. So you created a provision that would allow for land to be released from its permit. So there are specific qualifications, and we haven't talked about this in a while, so I'll read through it. Starting on line 10, change to non-jurisdictional use, release from permit. On application signed by each permittee, the District Commission may release land subject to a permit under this chapter from the obligations of that permit and the obligation to obtain amendments to a permit on finding of each of the following. The use of the land as of the date of the application is not the same as the use of the land that caused the obligation to obtain a permit under this chapter. The use of the land as of the date of the application does not constitute development or subdivision as defined in section 6001 of this title, and would not require a permit or permit amendment but for the fact that the land is already subject to a permit under this chapter. The permit or permittees are in compliance with the permit and their obligations under this chapter. It shall be a condition of each affirmative decision under this subsection that a subsequent proposal of a development or subdivision on the land to which the decision applies shall be subject to this chapter as if the land had never previously received a permit under this chapter. An application for a decision under this subsection shall be made on a form prescribed by the board. The form shall require evidence demonstrating that the application complies with subdivisions 1A through C of this section. The application shall be processed in a manner described in section 6084 of this title, and may be treated as a minor application under that section. In determining whether to treat as minor an application under this subsection, the District Commission shall apply the criteria of this subsection and not that of 6086A. So, this is providing for limited circumstances in which you can get rid of the permit. So, the land is currently being used for something different than what the original permit was for, and that the current use would not trigger Act 250, and the permittee is currently in compliance with the permit. So they haven't already violated the permit and are doing something that would bring enforcement action against them.
And this, I believe, is from a bill that's been introduced before, and is it on our wall? Do you
It's
remember?
not on,
It's not this year,
No.
but it's been in the past.
yeah, it's been introduced previously.
Okay.
May I ask you a question, just a clarified question?
Sure.
When we talk about the land, I mean, sometimes you have a subdivision that occurred that was under Act 250 subdivision, and one of the parcels is not used in that current what's your choice of language, is not the same as the use of land causing the obligation of the permit. Can this apply to that specific parcel? That's part of that. What comes to mind, I'll give you just an example. We have a industrial, in my town, we have an industrial section, zone, and about a number of acres of that industrial zone were sold to conserve as soccer fields. And yet, every time they want to put in a gazebo or something, they trigger Act 250. Those sorts of little things. So it's one parcel within the overall context of that Act 250 master plan for that industrial sector, yet I would hope that it would apply to, that subdivision that would fall under that particular Act 250 permit.
So everything under Act 250 is very fact dependent, and so this, I don't know what their original permit was for, and so this is saying if the current use is different than what was applied for originally, right, they can apply to be released. And so I don't know what,
Industrial, and now it's ball fields.
but it was only for industrial, or were
Yep.
those?
Any type of, it's our industrial zone. I just use that as an example that I'm familiar with, but it brings up the question of when we talk about land, and maybe we should define what we mean by land. That could be a parcel that's under Act 250.
It seems to me that they would be eligible to apply.
Yeah.
Yeah.
Right,
Totally.
okay.
And that's one of the points, I would think. It's not like that land was part of the industrial park's approval and it meets an open space requirement. And then they probably wouldn't
No, it
be
was
granted.
for
But
industrial.
it was just separate, so
Yep.
it's a different use, it would never trigger Act 250, a soccer field wouldn't, so that's what this is set up for.
Okay, love it.
I think the other example that we talked about extensively last year was the idea of a school building being converted into a house, because most residential doesn't trigger Act 250, but commercial and industrial uses often do.
But
So,
schools don't, because of the 10 acres. Because 10 acres for government project.
well, some schools trigger that.
Yeah. I'm just thinking of, if a school triggered Act 250, it's probably big enough to have many housing units in it if it's being converted to housing.
Right. So for all of these things, they're extremely fact dependent. That
Yeah.
was one of the examples that I remember. I'm sure there are probably others, but sure. I'll withdraw that because I'm sure there are other examples that are more illustrative.
Sorry. Okay. I think it's, Jim, did you have a thought?
I can give an example that fits this precisely. And when we get it, but I'm not using it to promote this one way or another, because when we get past Lee, I'm gonna say, I invoke Rule 47, which is what you might have done the other day when you were in here. I think it's Rule 47, which means I am abstaining because of a particular interest.
That's 75, I think.
Oh, 75? Yeah, you won't get far with
Stick with
47.
Get out the door, right?
But just, so I'm not promoting this one way or another because it exactly fits where I am. In 1977, we put our nearly 500-acre parcel into Act 250 for the purposes of creating a ski area. And in March of this year, most of that land, remaining land, after the bank got through with me, was conserved and is now owned by the town of Williston. And they are subject to Act 250 because that land was originally in 1977 part of Act 250. Became Act 250. The remaining 46 acres and houses and buildings that did not get conserved are still in Act 250 also. But they're not doing anything. They're some old farmhouses in the barn, you know, and they are not, as it says here, doing what was originally permitted for. So this bill would relieve our portion of our remaining portion of the property. If we want to use the word relieve, from Act 250, remove the property from Act 250. There are many other instances in the state of Vermont where this has happened, and that's where David Dean, who was the original author of this, said, you know, just like, why is it even there anymore? It doesn't need to be there anymore, and that's the language. Does not. Where is it?
Is everyone okay with this
Yeah.
language
Yeah.
being in?
Okay.
What was your point?
I had to get there.
I think it's that list.
Are we talking about slate quarries? Thank you.
Through that. Okay.
So the last remaining section that was on my list to review was your racial equity review on page 80, but the chair and I spoke recently about a counter proposal, so I didn't know if you wanted me to go through what you currently have, or do you want me to switch to your proposal? So currently in your bill, we heard testimony last year from a few different people who raised concerns of racial equity and some potential environmental justice issues related to Act 250, and we heard that testimony fairly late in the session, so we decided it might need study by someone other than just what we could do at the end of the session. So we drafted a review study, and so I'm on page 80. Pursuant to the duties and powers established under 3 VSA Chapter 68, the Executive Director of Racial Equity, in cooperation with the Racial Equity Advisory Panel and the Human Rights Commission, shall conduct a comprehensive review of the processes, procedures, and language of Act 250 to assess the extent to which Act 250 has contributed to adverse impacts on racial equity and diversity within the state. The review shall identify the impacts of acts or decisions made pursuant to Act 250 on the inequities in land ownership and land distribution within the state, measure the extent to which minority populations in the state have incurred disproportional environmental impacts due to acts or decisions of the state pursuant to Act 250, assess the capability of the current public participation processes, notice requirements, and appointment processes under Act 250 to fairly represent the interests of minority populations within the state, and recommend legislative changes to Act 250 necessary to achieve the goals of racial equity and diversity representation for minority population. On or before October 15th, 2020, the Director of Racial Equity shall report to the General Assembly with its findings and any recommendations for legislative action. So, when I drafted this, the Executive Director of Racial Equity had not yet been appointed, so we didn't have anyone to ask to respond to this proposal, and she has been appointed since then, so it may be worth hearing from her if you would like to pursue this proposal.
Can we get her in here before 3?
Before I think she just works across the street, so.
Okay, we'll get her on the schedule for next week, I guess.
Didn't she speak
Sounds
down
done.
the House chamber?
She did.
Yeah.
Yeah.
I don't know, what is, I don't know her name.
Davis, or Susanna Davis?
Yeah.
Davis is her last
Suzanne.
I think so. I'm sorry, I don't.
Yeah, that's right.
Kaya came in here with,
Kinda did come in. The other thing that's happened is that, I think the Middlebury College students that I worked with this past fall made a recommendation, well, I mean, I had them look into, I asked them to do it, but using the definition, I asked them to look into this issue and consider what would make sense as a criteria that would address racial, environmental justice during Act 250 review. And so Ellen has looked up the definition that the EPA uses and come up with some language for that, which I think you have with us.
I do.
And as we shift gears, is all of that language together with the other? So
Yes, it's with the other.
why don't you
proposal.
introduce that if you want to?
All right. So a few days ago, we had a conversation about district commissions and strengthening district commissions. And I took some of the comments you made and tried to piece them together into a proposal to strengthen the district commissions in order to have hearings on the record so that they could be that appeals could be on the record. So I have drafted that as well as some environmental justice language. So I will say, and so it is on the website. Mark also made copies. I called it the Sheldon Amendment, but that's just because I was sleepy when I drafted this. But so there is a series of sections related to strengthening the district commissions, and it was a little vague to me, everything that was needed to address your concerns, so I hope I got it all, but if I didn't, we can talk about that. And also there was Jim Dumont, his testimony contributed some language, so this is what I came up with based on Jim Dumont's testimony as well as the conversation around on the record appeals. Do you want to start with the environmental justice stuff?
Sure.
Because it's at the end.
Yeah.
The environmental justice piece is on page 15, and it's short. It's very short. So I add a new definition of environmental justice to the definition section of Act 250, and it is based on the EPA definition of environmental justice. So environmental justice means the fair treatment and meaningful involvement of all people regardless of race, color, national origin, or income with respect to the development, implementation, and enforcement of this chapter. And then I add a new criteria. And I added it to 9. I called it 9M, but it could be a different letter at this point. So environmental justice, I'm on line 12. A permit will be granted for the development or subdivision when it has been demonstrated by the applicant that, in addition to all other applicable criteria, no group of people will bear a disproportionate share of the negative environmental consequences of the development or subdivision.
Carol.
If you have no group of people here, and on the other page you have race, color, national origin, or income, does that mean that if you didn't call it out in 38 at the bottom of 15, that it's okay because you wrote group of people? So what I'm trying to get at is, what if it's people who have been incarcerated in the past, people with substance abuse issues, people with mental health issues, people with children, single people with children, gender things. Can those things, does that mean no group of people? Or do you have to list that underneath environmental justice? or both?
So I admit this is an odd piece of drafting, and it is because I didn't quite know how to use the phrase environmental justice in a statement. So the criteria uses the phrase no group of people, but the heading is environmental justice, and so my intent is that the environmental justice header is used to for the courts to interpret the intent. If you would like different language to be more specific, that's what we should discuss, but I was trying to work environmental justice into a permit criteria, and it was proving challenging.
I don't know. I'll leave that to you, but I do wanna make sure that that this is not
A
a
limitation?
limitation.
Yeah, I don't see it as one, but if you have specific concern, I can. The definition in 6001 is almost superfluous. We don't really need it, but
So you could just write of all people.
yeah.
Jim?
So wordsmithing by a group is dangerous, but your point is well taken, Carol, and I'm thinking that if we take in environmental justice, M, on page 16, and use the no group of people and pull it into the definition, and so on page 15, where it says fair and meaningful involvement I was gonna say.
Can I just raise this up one level?
Sorry.
So
Yeah.
this
Go
is a
ahead.
new criteria, and we did take some limited testimony on environmental justice issues related to land use in general at the end of last session from a PhD student from UVM. And we heard from Keisha and her group that was starting a process, actually. And we also heard from Mark Hughes, and I don't remember the name of his group. He's asked maybe to come back in. I'm just looking for higher level thoughts on like how do we address this issue in this update?
My highest level thought is, as long as, is not to restrict it. So we don't have to take a lot more testimony in my mind, as long as no group of people includes everybody, every kind of thing.
So I'm hearing you support having it in.
It's all right with me if you think that it works.
I'm just wondering, how do we evaluate it? Carrie and then Lee.
I appreciate that. I'd like to keep it in. I'd like to hear from the director, because I don't know if this is the definition, if it's broad enough, if this is the right definition. And especially when you're talking about environmental justice, it doesn't touch upon the rights of people to live in a safe environment. And so, live and play and so I would appreciate hearing from her, just to make sure we're being consistent in the application of a common definition in this context.
My comment is, we already have federal laws and state laws that require all people to be treated equally, and I just wonder, with this specific sentence or sentences, how is this going to make anything different or correct anything? I'm just wondering if it's redundant, and if we do need it there, why do we need it there?
Well, one thing that was brought to my attention, for example, was the current highway project in Burlington, displacing low-income people. That's kind of, for me, the classic example of kind of environmental social justice, if you will. And understanding that's often what happens when we do these projects.
So in reality then, we are not necessarily treating all people equal. That's right, we have state and federal laws. So you feel that this then would be something that might correct these things.
I think that's why I'm looking at it, you know. I don't know
I mean,
what it is. I'm curious about how to explore if it would address it.
I have no problem with being there, I just wonder how do we deal with it? Even though it's written there, how do you deal with such a thing?
We did hear, Billy just left, but the Agency of Natural Resources was doing something with the EPA definitions. That might be under Keisha's testimony from last year. Okay, so I was looking for ideas on what, I know we're gonna have Ms. Davis and so, yeah, Jim.
I think for purposes, have we heard this before, of the next iteration, we use this language that you've made. When you when you contact Ms. Davis, you might send her the language that we have in our next iteration and ask her to be prepared to speak to that. So that
She's ready.
it's just not randomly coming in here with a pop quiz.
And Mark Hughes, I guess. You could respond to him and have just like an hour. We have to, early
Also, ethnicities, is this ethnicity?
Let's not wordsmith right now.
I know, but I'm just saying, we're not hearing from everybody, but just hearing from some, so I just wanna make sure we,
Yeah, so I'm open to hearing.
yeah.
If you guys have ideas of someone else who's not gonna like this, or who's gonna give us advice
As long as
on,
everybody's included.
you know, how this might, we maybe should hear from the NRB. Yeah, so.
The agent,
The agent?
citizen,
Plenty of them in the building.
let me go fast.
Okay, I have a request for a 5-minute break. I think we're gonna go past 3 today though, and I wanna get through this next section that Ellen has drafted for us, and I know we have people with us right now who want us to do that as well, and wanna be here for it, so.
So I missed
For last year, we are talking about, the district commissions and our decision to explore the idea of having them go on the record and looking for ways to support them better. I will say that, you know, talking about so let's go through what Ellen has presented us and then we'll see where that takes us.
All right, so I add a number of sections to Act 250 to strengthen the district commissions in multiple ways, including having their review be create a record that can then be appealed on the record. So adding section 6085A, recorded hearings. Any appeal under section 6089, which is the appeal section of Act 250, shall be a review of the record of the proceeding before the district commission in accordance with 8504H3, which we will get to later. Within 10 calendar days of receipt of a complete application under section 6084 of this title, the district commission shall provide notice of the recorded hearings in accordance with the procedures of subdivision 6084B1. And so that lists the parties that need notification.
Is 10 calendar days what the appeal time is now?
To receive notice that an application has been filed, yes. Each of the following shall apply to the review of an application under this section. The district commission shall extend the hearing schedule or take other appropriate action as necessary to provide a fair and reasonable opportunity for parties to prepare, present, and respond to evidence without creating undue delay in the review of the application. The district commission may require parties to submit pre-filed testimony and exhibits. If the district commission requires submission of pre-filed evidence, the applicant and any parties supporting the application shall submit their pre-filed direct evidence first, and then other parties shall be given a reasonable opportunity to submit their pre-filed direct evidence. A district commission may then allow the submission or presentation of rebuttal testimony and exhibits in the sequence and form that it determines to be appropriate. Unless the parties agree otherwise, the District Commission, in a pre-hearing order, shall establish the type, sequence, and amount of discovery available under Rules 26 through 37 of the Vermont Rules of Civil Procedure, limiting the discovery permitted to that necessary for a full and fair determination of the proceeding. On receipt of a request from the District Commission for assistance with regard to an application heard under this section, the Board shall provide assistance to the District Commission as necessary, or the District Commission may hire personnel pursuant to Section 6022 of this title. So, I'm going to stop there for a second. Our discussion the other day, I was a little unclear as to where the support for the District Commission is coming from. We're going to talk about in a second that the District Commissions should have an attorney working with them on these recorded hearings, and I was unclear if you wanted that attorney to be an attorney from the board, one of the attorneys that the NRB already has, or if they should be hiring their own. And so later in this bill, under 6022, I do allow for them to hire their own, but I was unclear. So I guess it could stay both as I have phrased it, or you could make a decision about where that personnel is coming from. At the expense of the applicant, the District Commission shall record by video any hearing on an application. In the event that appeal is taken from a District Commission act or decision on such an application, the District Commission shall provide the Environmental Division with the original recording of the hearing and a copy of the complete written record, and shall make and preserve a copy of the original recording for its own records. Alright, so the next section amends 6085, which is an existing section. And so subsection E strikes references to the Natural Resources Board. So the District Commission, acting through one or more duly authorized representatives at any pre-hearing conference or at any other times deemed appropriate by the District Commission, shall promote expeditious, informal, and non-adversarial resolution of issues. Require the timely exchange of information concerning the application, and encourage participants to settle differences. So this is taking power away from the board to one of the things we discussed was they're participating in settlement decisions. So this was one of Jim Dumont's suggestions about removing that power.
So currently the language is the Natural Resources Board and any District Commission.
Yes.
Okay. Alright.
But may I ask, does that conflict with ex parte? If they're setting up a formal.
That's later.
Yeah, I addressed that later. You can make a decision about that, a policy choice about whether or not you want the District Commission to be able to encourage settlement negotiations or not. But there is a provision for that later. So skipping down to line 17, at the pre-hearing conference or a subsequent scheduling hearing or hearings, the District Commission shall establish a schedule for pretrial discovery pursuant to the rules of the Vermont Rules of Civil Procedure, and for disclosure of and discovery with regard to any expert testimony by experts retained by the District Commission. The Commission shall have the same authority to supervise or limit pretrial discovery as a Superior Court judge under the Rules of Civil Procedure. Alright, next we get into the ethical standards. So, we're striking reference to the board and the chair of the board under this because they're not part of this process anymore. So, and this was at the suggestion of Jim Dumont also, so we can talk about this, but the chair and members of each district commission shall comply with the following ethical standards. And so this language on the rest of the page is what's already an existing statute. And then on to page 5 is where I add the new language about ex parte communications. So starting on line 7, I took the language from Canon 3 of the Vermont Judicial Code and adapted it for the district commissions. So the district commission shall not initiate, permit, or consider ex parte communications or consider other communications made to the district commission outside the presence of the parties concerning a pending or impending proceeding, except that, where circumstances require ex parte communications for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits are authorized, provided the district commission reasonably believes no party will gain a procedural or tactical advantage as a result of the ex parte communication, and the district commission makes provision promptly to notify all parties of the substance of the ex parte communication and allows an opportunity to respond. The district commission may obtain the advice of a disinterested expert on the law applicable to the proceeding if the district commission gives notice to the person consulted and the substance of the advice and affords the parties reasonable opportunity to respond. The district commission may consult with personnel whose function is to aid the district commission in carrying out its adjudicative responsibilities. The district commission may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to mediate or settle matters pending before the district commission. The district commission may initiate or consider any ex parte communications when expressly authorized by law to do so. So, full disclosure, I adapted this from the judicial code, and there may be some things in there that you don't want or need. So the references to the board are struck in the rest of this. Okay, this is about disqualification. So as soon as practicable after grounds become known, a party may move to disqualify a district commissioner from a particular matter before the district commission. I started on line 11, sorry, sub B, still on page 6. Yeah. So we're taking away power again from the board to participate in these disqualifications. So the power is going to be all with the district commissions on this. Yep, disqualification of a member for interest in what's going on. So the motion shall contain a clear statement of specific grounds for disqualification and when such grounds first became known. On receipt of the motion, a district commissioner who is the subject of the motion shall issue a decision after consultation with the commission's counsel. So currently, if there is concern about a district commissioner, I think the board is usually involved in deciding whether the disqualification should go forward, and this is the suggestion from Jim Dumont was that the board shouldn't be involved in this decision anymore.
Do you need to explicitly state appearance of or perceived conflict of interest, or is this good enough?
So I think that is actually part of what we sort of skipped over was back on page 5, back on page 4, they have the disqualification from interest is in there. On line 12. So that's existing. And so is this language, which is being tweaked to take the board out of the decision-making process. On page 7, on disqualification of a district commissioner under this subsection, the chair of the district commission shall assign another district commissioner to take the place of the disqualified commissioner. The struck language starting on line 9 again takes the power away from the board as part of this process to disqualify.
So this language is still in there even though the board's not hearing appeals.
Right.
Or
Right.
they're not, so it kinda needed updating anyway.
Yep.
Potentially, yeah.
Yeah.
Yep. So it strikes the rest of the references to the board under these ethical standards. And then onto page 8. Amending section 6084. Hearings on major applications shall be governed by the Vermont Administrative Procedure Act. Each district commission shall be assisted by counsel, shall have the authority to retain expert witnesses, and together with their counsel shall comply with the ethical standard established in 6031 of this title. So that's what we were just looking at. Section 5, 6027, powers. So this is another thing that I sort of inferred from the conversation we had the other day. This is striking the Natural Resources Board's power to participate as a party in all matters before the environmental court.
But this says repealed.
Yeah, I struck it. Yeah, so they would no longer be allowed to participate as a party.
I'm confused though, like when we strike, we haven't repealed it yet. Why does it say repealed in parentheses?
That's the standard form that we used. That when you strike a section.
That's in law now.
Yep. No. So.
But we've crossed out other things and it doesn't say repealed, so I don't understand why it says it here.
It's a drafting conformance that we use.
But the first time I've seen it today, even though we've had others struck.
No, twice today, so I've
You've seen it twice? Okay.
I've done with the,
Oh, yeah.
It depends on where it occurs in a section of statute.
I thought repealed was what was in statute. I mean, we repealed it and it says that in statute, sometimes it'll say that, repealed.
Mm-hmm. Yeah.
I'm trying to figure out if this is a double negative. What's in statute right now?
Currently in statute, the Natural Resources Board may participate as a party in all matters before the Environmental Division.
oh, so that's in statute, and this would be, okay.
Right. It's repealed.
So the word repealed is underlined, and so that's a new piece of language.
Thank you.
Yep.
It's confusing when it shows up. How come it's not everywhere we've crossed stuff out?
When something is considered an independent clause, because there are going to be things before and after it, the J will remain as a designation, but it will say repealed next to it if you pass this.
Oh, right. That's what I was trying to get at.
Oh.
Sorry. Friday afternoon, brain's not working. But so the intent of this,
Is to strike the ability of the Natural Resources Board to participate before as a party. Section 6088, burden of proof. So this was also a suggestion from Jim Dumont, and I don't know how much you talked about it, and it's a little bit confusing, but so most of this language is what is currently in your bill, but the new language from Jim is, he's not here, is he? Okay, is on line 12. So, with respect to permit conditions to mitigate impacts under subdivisions 6086 A 5 through 8 of this title, so traffic, educational services, municipal services, aesthetics. The burden shall be on the applicant to demonstrate that it is not feasible to avoid the impact. And I spoke to Jim last night, and this was one of his specific concerns. I think he talked to you about when permit conditions are appealed. It's currently on the opponent, not the applicant.
Didn't we talk about this today under burden of proof?
We talked about it a little bit, but this is very specifically about permit conditions.
Oh,
So, he had some examples, and
to mitigate.
yeah, so permit conditions are usually added to mitigate adverse impacts, so that to mitigate down the impact so that the permit can go forward. I don't know a ton about this area, so you may need more testimony on this issue. Next, 6007, this is jurisdictional opinions, and so this section moves the ability to issue a jurisdictional opinion from a district coordinator to the district commission. And so that's what this section does. It just replaces district coordinator with district commission.
And, yep, excuse me, may I ask a question?
Yep.
Had we talked about that? Had we
That was part of the discussion you had the other day, which was sort of a little vague and amorphous. So I don't think we've had a ton of testimony on it, but it was part of the discussion of how to strengthen district commissions.
I think part of that discussion was that it would be up to the district commission to either go along with the district coordinator's jurisdictional opinion or not. I mean, they would have the ability to say, no, we don't agree with that interpretation of the law, but they just want to do it. So otherwise, you're gonna make whoever's working for the district commission, you do the jurisdictional opinion anyway. I mean, if it comes from the district coordinator and it goes before the district commission, they still have the power in order to say, okay, we go along with that or we don't. I mean, part of the problem with us is we didn't know where you could appeal the coordinator's jurisdictional opinion. It looked like it got just hung out there. We didn't know where it went. I didn't know who would go to appeal, where you would go to appeal a district coordinator's jurisdictional opinion. And I think we wanted to make sure it was back to the district commission where they would have that power.
So that's not what this does. This is saying that a person may submit a request for a jurisdictional opinion to the district commission, and they would then issue the jurisdictional opinion.
Doesn't deal with where it gets appealed.
No, but that's already in statute. Those go to the environmental court. That happens fairly frequently.
I was just thinking of the case up in Burke with the Victory Lands, and I was told that the town clerk asked the district coordinator for a jurisdictional opinion on whether or not that particular mountain bike trail required an Act 250, and she rendered an opinion that it did.
Right, and they could appeal it to the environmental court.
Yeah, but I mean, so the district commission was never really
Right.
involved in it. and
Right.
that's-
They're not right now.
Yeah.
This requires that there
Yeah.
would be.
Yeah, that's right.
This changes that.
And I would still think the district coordinator would probably write the opinion perhaps.
That's right.
Yeah.
Okay, I'm just trying to get it straight.
Yeah, yep. Do you have a question, Carrie, or?
Nope.
Okay.
Me neither.
Alright, so the next section amends section 6022, the personnel section. The top of page 11. District commissions may retain legal counsel, scientists, engineers, experts, investigators, temporary employees, and administrative personnel to assist in its recorded hearings. The district commissions may use funds collected under 6083A of this title for this purpose. And that's the next section we're gonna go into. So, Jim Dumont proposed that in order to fund these additional personnel, that there be an additional fee collected on Act 250 permit fees. So, 6,083A, Act 250 permit fees. So starting on line, so there's a general fee for Act 250 permits. Starting on line 20, an additional $3 for every $1,000 of construction costs shall be deposited in the fund created under section 6029 of this title for reimbursement of the district commission's costs incurred in retaining its own expert witnesses in that matter. Any unused fee shall be returned to the applicant at the conclusion of the matter. So this was the proposal from Jim Dumont. It's sort of sets up a little bit like a bill bag structure where a fee is added if the district commission needs additional support staff, but unused portions of that fee will be returned.
How does that work now?
It doesn't.
Well, what does that mean? The
back.
fees
I mean,
themselves
yeah, the
are-
fee, I mean, in terms of, if the district commission don't they now have to, more or less consult with experts, or if, no,
They don't get them.
No.
they don't.
That's one of them. Oh, Jim.
But generally speaking, bill back authority is granted in statute for other situations. For this, the agency, for instance, can bill back for special counsel or special scientific work.
Yeah, this is not directly analogous, but it's
No,
a similar.
no, it's
yeah.
a similar
Yeah.
situation, yeah. It's not direct. Yep.
Right, so this is a policy consideration you have to think about, because this is one way of accomplishing it. You could also increase the fees generally so that the agency in general had a larger budget to hire staff to permanently staff the district commissions. This is sort of setting up on a case-by-case basis situation. But so it may need some work on that. Further down, it also adds a similar fee for projects that involve extraction of earth resources, which the general fee is calculated slightly differently. So starting on line 15, an additional 2 cents per cubic yard of the first 1,000,000 cubic yards, and 1 cent per cubic yard of any such earth resource extraction above 1,000,000 cubic yards shall be deposited in the fund created under 6029 for reimbursement of the district commission's costs incurred in retaining its own expert witnesses in that matter. Any unused fee shall be returned to the applicant at the conclusion of the matter.
Detail, but you wanna say minus any administrative fees.
Yeah, it might need to, the word expert witness may need to be changed. Cause in 6022, I reference beyond just expert witnesses, I also reference other experts and counsel. But I wrote this sort of quickly, so that might need some work. And then on page 13, new language on line 14, fees other than fees paid to reimburse the commission for expenditures on expert witnesses shall not be required for projects undertaken by municipal agencies or by state governmental agencies except for publication and reporting costs. And then, I think this is the last section. 10 VSA 8504. So now we're in the section related to appeals to the Environmental Division. On page 14, so I strike the reference to district coordinator decisions because those decisions are now made by the district commission. So here on line 8, Act 250 jurisdictional determinations by a district coordinator now says district commission. And so in this section I changed the reference to the district commission. And then finally, on page 15, de novo hearings. So currently, hearings before the Environmental Division of the court are de novo, except for the specific cases listed here. And the new language added on line 11 says, a permit decision from a district commission under chapter 151, which shall be on the record. So, permit decisions made on the record are appealed on the record to the Environmental Division.
Thank you.
The end.
Questions?
Quick question. With this, with the districts that we intended, are we all in favor of going this way with the 9 districts as we've got it outlined here? Have we all come to the conclusion that that is what we want and that's what we're going forward with?
I guess what I would propose is that we have a conversation about the ramifications of this, and it might lead us to that answer. So I think we're now kind of in this exploration of the on-the-record idea, and the idea that we could, we're exploring if we can support district commissions to make better decisions or appealable decisions.
So we will have more talk on what we just went through.
Yeah, but we're gonna have hopefully some right now. So if you wanna start us off, go for it.
No, nothing in specific. I just, I listened to what Carrie had to say, and I've talked with other people, and I'm still kind of open to the other method of having a more centralized group making this sort of decision. I do have some reservations there and here, and I just felt that it would be good if we had more talk
Sure.
before we go.
Yeah, we are having more talk.
Okay.
Go ahead.
I'll agree with everything Representative Morgan just said, but also, I'm assuming de novo was chosen for a reason back then, and we've heard people say it would be helpful to be on the record, but at least I don't think I've heard the reason why de novo was chosen in the first place, and what the benefits of having a de novo hearing are. So I'd like to hear that stuff, that we hear. If anyone in the room can just explain that now, that's fine, but.
Well, I think that what you'll hear is that going on the record makes it formal and
Right.
less user-friendly, and that's what we're, hearing again from people, is that the on-the-record is an impediment to public engagement. The joint proposal as it came to us, for me, didn't address the regional representation and didn't flesh out, it said, and we want it to be user-friendly for the public, but it didn't spell that out. And so, I don't know if I've heard too many people supporting on the record.
Oh.
So I think we sort of have, again, we have and I don't know that this proposal in particular addresses the concerns around strengthening the board itself, which is certainly something that I am interested in doing. So
Say that aspect again, that last sentence.
I'm not sure that our current pursuit of spending resources to prop up or support the district commissions doesn't address the, I think, mutually recognized concerns around the board. It's sort of strengthening the board. It kind of keeps them out of the loop. And I think that we have, and yeah, so thinking about the things like if we want to address the strengthening the board, and providing better expertise or witnesses. I think that the Joint Commission actually had money for that board to have expert witnesses. Am I right about that, John?
Yeah, I think it gave them the authority, and it allowed Bill back to be, this is John Groveman, just for the record from BNRC, it allowed for Bill back to hire expert witnesses to hear applications before the board.
Yeah. So I guess I'm starting to think about, I keep thinking about what are the things we're trying to address rather than necessarily who's doing which parts of it. And so I think what I've heard from this committee is an interest in making sure that regional input on projects is meaningful, right? And so in the original joint proposal, it didn't have them as, the members from the regions were not full voting members, for example. I think it's quite possible we could make them full voting members if we went with that model. But, so I think we have some moving parts and pieces. I've gotten some emails about on the record, just from people who are following our process, and I'm not sure any of them have been particularly supportive of it. So I'm not as hopeful on that as I was.
Right, so this proposal is sort of a third, as it stands at the moment, is sort of a third option, because your bill and the joint proposal contemplate taking Act 250 appeals away from the court, and this, what I just walked through, keeps the appeals going to the court, but they're now on the record. So, different paths.
There's still three.
Yes, and
Processes.
they would still go to the Supreme Court after that, so there's still the extra level of appeal.
Yeah, and I definitely hear the concern over the district commission process being the dress rehearsal. Yeah. Sounds great. Jim?
I think I feel that the on the record at the district commissions does strengthen the district commissions. It gives them that voice that when that is done, what they say will not be obviated by another, or ignored, which we've gotten testimony happens. It may get reversed by a higher court, but it will not get ignored. And we've heard testimony that it does get ignored. So I think it empowers them in that way. Whether we've given them enough tools to produce it, I'm not sure. And we haven't done anything really to strengthen the existing Natural Resources Board, which I think we should do also, the chair mentioned. It's not, we've parsed out some of their, right now, powers away from the district commissions and but not giving them more direction, if you will, or specific direction. I think it's already in statute what they're supposed to be doing, which is helping the district commissions with education and recruitment and who knows, and a bunch of other things. But I think they need more resources, and certainly the district commissions need more resources if we're empowering them to do this work. And that is spoken to in this bill. I get the idea that there is some pushback against the trial-esque atmosphere that this will create at the local level, district commissions, and people don't like that. But I will also say that if they didn't like the decision as currently developed there and it gets appealed, they will have a trial atmosphere, only it'll be in Montpelier. And in fact, they may end up having 2 trial atmospheres, even, because the original discovery at the district commission is certainly original, it's new, it's original. Then when it goes to the E-Court, currently it's de novo, and that sort of speaks to, it gives the dissenters another bite at that, a bigger bite at the apple than they might have otherwise gotten, but it's another whole trial and another huge expense and amount of time. So I think one of the things we are trying to do, and the administration is trying to do, is make sure everybody gets a fair look at this, make it more predictable, and speed it up so that so that projects aren't held out there for extended periods of time at extended expenses. And I think this really helps with that. I think we heard that an on-the-record appeal at the E-Court would not be a significant amount of expense for anybody in dollars or time compared to the de novo. And then we also heard that after those appeals, only a few end up going to the Supreme Court. So I think we've accomplished what we all want to do in that regard by doing this. And I think it may just cut in half the amount of pain and the amount of dollars and the amount of time, and as a friend of mine would say, brain injury, by just doing it once, doing it right, doing it at home, and then it's on the record after that.
But there has always been some concern about fair and equitable treatment, district to district. Is this going to help in any manner so that things do appear to be more fair and equitable from one district to another?
For me,
where it might be good here, next district, well, it might be a whole different decision. Same facts. Is this going to, in any way, correct that?
Well, in my mind, yes, because there's an entire description of how things will be done that we went through in this, and they weren't just dragged out of thin air or whole cloth. I'm sure council took those from how it's done in court proceedings. Would you say that's accurate? Are you aware of the question?
He's still with us.
Yeah.
I took the language primarily from a few places, especially that almost every year a bill is introduced to make Act 250 hearings be on the record. There is a bill almost every year, so I have gleaned it from that.
So you didn't make it up?
I didn't make it up.
No.
I mean, you can tell the places I sort of made it up.
So they'll be discovered on Tuesday if we move this section forward. But I think it does level the playing field around the state because of all the requirements of how it's supposed to be scheduled and done and heard and no secret backdoor conversations and on and on.
So a centralized decision-making process, in your view, would not be a better way of making that a level playing field. That's
Yeah.
my concern. right
Yeah,
there.
yeah, I don't know that it would make that better. I don't think it would make it worse. But what it did do in the proposal, from the joint proposal, was take the muscle out of Milton, and a little alliteration there, but out of your district, and centralize it here. Remember, they get 3 votes, our district commission gets 2. And by the way, we don't really have the district commission anymore. We just have a couple of coordinators and alternate. And so maybe,
I guess we're certainly leaning away from that, so I won't comment any further.
Just to clarify, part of our discussion, what we had heard with respect to the joint proposal was to reduce the number of processes, so that it was going to go from the first hearing and then appeal to Supreme Court. What this does is doesn't do that, even though we've moved to from de novo to on the record, we're still having those 3 steps, correct? Yes. So there's no savings in terms of cost to all parties concerned. They're still having to, even though it's on the record, they're still having to take part in a more quasi-judicial system up front, an appeals process to the Vermont Superior Court, Environmental Division, and then if it continues, and then the Supreme Court.
Yes, although I would say, I'm not sure I could say that it will not result in cost savings, because the court, the appeal that will happen at the environmental court will be different. It will be a smaller type of appeal, because it'll be on limited issues. But I don't know specifically about the cost.
Is this, as we have it here, do you see a more expedited, more quickly processed application? Or is it going to be, as the major concern appears to be with anybody that I've ever talked to, is it takes so long, it goes on forever. Is this going to alleviate that? I don't see that. I see the same steps. Whereas as I indicated, a more centralized, it seems to me that it would make it quicker, and I would almost guess less expensive. But
Well, the funny thing is, so few Act 250 projects are appealed, and we're creating on the record, which is conceivably going to slow that original process down in order to address these few. I mean, this whole conversation, frankly, is about a few projects that get appealed. It's so odd that we're restructuring how Act 250 is administered for a few projects that get appealed.
And we have had testimony from somebody who said, Act 250 held them up, and then Ed Stanek said, well, no, actually, Act 250 was done in 3 weeks for that person. It was ANR and historic preservation that held the project up. They got bad advice. They spent more money than they should have. Nothing to do with Act 250. So we can make law and change law based on perception, or we can learn what we've learned and then deal with that and try to educate people, or let people keep saying the same stuff they keep saying. What can we do? We can't stop people from saying the same stuff they keep saying. Even if you say, well, actually, that isn't true. Not that everything that everyone's saying isn't true. It's just that some things are incorrect.
But you're an attorney, So, have you ever, just out of curiosity, have you ever done any Act 250 stuff? So, okay, just wanted to talk to you about the process if you have, would you?
All right. So, it has been brought to my attention that there was an offer put on the table for us to at least hear from some folks who were not proposers of the joint proposal, but supportive of it. And so, I think we will provide that opportunity next week for that to happen. What else for next steps? We will.
So I have an uncomfortable question. I'm going to be giving you a new draft.
Yeah, oh, that's a great question. I was gonna ask about how to address the whole thing in the
Well,
new draft.
I mean,
No, it's a good question. It's a fair question that was on my list of things
Okay.
to talk about. Well, I am wondering, you just gave us a new draft of this section, as far as I'm concerned. And so I think that my inclination right now, I'm thinking a little bit out loud, is to say to you, don't touch the board structure section. And do the substantive changes we've asked you to do for the criteria and the jurisdiction. And you've given us this, which is very helpful and starts to address some of our concerns. The joint proposal addresses some of our concerns, and the verb addresses some of our concerns. Those all exist, and we need to kind of figure out how we're gonna move that forward. I mean, right? So some folks in this building who have much more experience in this world than I do, we're feeling like we've taken on a lot, and so I don't know, maybe this is too much for right now. So I think we know that we want to put the best bill out there that we can. But we also know we want to put a bill out there. So let's on Tuesday we'll have your draft, which is fabulous. You can hear from some folks who did not get a chance to speak in favor of the joint proposal, and we'll hear from Trails folks next week.
Whoa.
No.
Really?
We've only got 4
Put
days.
yourself up on the line there.
I know. All right. They said we'll hear from them next week. No, we'll hear from them.
Excuse.
I'm not sure who else is teed up for next week, but we will. This has been a fabulous week. Thank you all. We've worked incredibly hard,
And Ellen.
and Ellen's worked incredibly hard. So thank you all. Thanks for staying a little bit later than we usually do.
Can I ask one question?
John.
So I think if you're gonna pursue the on the record, you should take some testimony on it, because I think people are concerned about it, and there are a lot of issues with it that you would benefit from hearing about from people who have a lot of experience with the process and what that system would result in from, different perspectives, and I think those
I mean,
really
I think that I certainly have gotten some testimony from those folks. It's written, people have been submitting it via email written, and I think it's all been to the whole committee. And you're right.
Okay.
We
I mean,
would-
just if you're really gonna seriously pursue it, it's as big a deal, if not bigger than the joint proposal language that, so that you should really
Yes.
do a deep dive.
and I don't think we took very much, if any, testimony on it last year, because we were pursuing the verb as opposed to this.
You're right.
Do we have a SharePoint, or is that just filed by witness when you said we received
Well, you've been
email?
getting them from either from the witness directly or from Mark. Some
Yes.
people have sent me
Emails.
and Mark stuff, and then Mark sends it to all of you
Oh.
and
You
posts
put it
it.
right on, you put
Oh.
them right out
Have you
there.
been doing that? Have you been
Yeah,
sending
I've
it?
forwarded anything that I've gotten, with one exception, which was actually already sent to every single one.
Oh,
Yeah, you'll see a lot of Mark.
But if it's
Oh,
from
man.
me and it's to House Natural, it's a forward and it's from somebody who's got something to say, and there's a file attached.
Yeah.
So there's been a lot of,
Yeah, there
there's been a lot of
Thank you.
testimony on this.
So your name's on them when they.
It comes
Yes.
from me and it's been sent to House
Yeah,
Natural.
I always look for your names.
Ah.
I just wanna.
Mark.
Oh, no, Mark, all the way down through there.
Obviously, Ken's been ignoring your emails.
Well, that's your prerogative, that's fine.
No, not intentionally. I thank you for that.
We are adjourned for the day. Thank you.